So the very start of it is the Tres Anciens Coutumiers, which is the original source of, it says in that case Jersey law, but that would be true, by the same logic, of Channel Island law as a whole. It dates to around about the same time as the communes, the separation. But of course it wasn't somebody legislating, it was someone trying to write down what was already in existence. It involves a significant amount of substantive law. There's no evidence of it actually being used in the Channel Islands as such, but then there's no particular written sources from the Channel Islands in the early 13th century. It's never been cited for any rule of law, as far as anyone can tell, in any of the Channel Island courts. Now, the interesting thing, which I think is what the Royal Commissioners of the 1840s had to say about it, which is a favourite exam question from Jersey. The Royal Commissioners were sent to first Jersey and then Guernsey. They were the same people, to inquire into the state of criminal law. And when they were in Jersey, they didn't repeat themselves completely when they reported in Guernsey, but when they were in Jersey, they said that this was actually the only law that should be relevant in the Channel Islands. Because after 1204, Jersey, Guernsey are no longer part politically of Normandy. So what does the law of Normandy have to do with those Channel Islands? To which we now know the answer is because it's the nature of customary law to borrow from your neighbours, even if that, particularly if they're the neighbours of which you've until very recently been politically apart. Another interesting thing is a recent article by a chap called Vincent, which is cited there, which is certainly when it began to be republished, the Tres Anciens Coutumiers seems to have been changed for political reasons, if you were Norman, in that it was trying to, just as people in Jersey and Guernsey would be worried about being annexed by Edward I, so if you've just been effectively conquered by Philip Augustus, you're probably a little bit worried that he's going to take away your customs. So they kind of embroidered their own. So the coutumier was embroidered in order to try and maintain ideas that would support Norman independence or autonomy as against the King of France, to keep it a duchy. The Grand Coutumier is more important. I'm not entirely sure why it's kind of come out like this, but that's the way it is. It's mainly procedural law and not substantive law. In fact, the Tres Anciens Coutumiers was more substantive law. And the reality of the matter is that back in the 13th century, you didn't really have paper, you certainly didn't have printing, and you wouldn't necessarily want to write down things twice. So if you already had a manual which was doing its job perfectly well in substantive law, you wouldn't necessarily want to go and recapitulate the whole thing. So it's probably designed to be read with rather than supersede the Tres Anciens Coutumiers. Now it was never rewritten, but this was written in the second half of the 13th century, probably around 1250, 1260, is that probably about right? It's not really important exactly when it was written for the first time. It was never rewritten, but in the nature of the time, they would just annotate it and then comment upon the annotations and so on and so forth. But this is the oldest document that's actually been cited in the Channel Island courts. Probably ought to have gone back to add a few more comments about that. It's the document, as we've seen, that the Channel Islands referred to as providing their law when challenged. it's also necessary to remember that Terrier, over there, the big volume, is actually largely a work on the Grand Coutumier, so everything that came after the Grand Coutumier in terms of customary Norman sources before they had a royal redaction was actually a commentary on the Grand Coutumier. Nobody sat down to try and rewrite everything. No one sat down to try and do the job again, not even Terrier. And of course, that means that Terrier, a commentary on the Grand Coutumier, is the basis for the approbation. So there you have a very clear family tree line. So if you were a legal history genealogist, you have a clear genealogy back to the Grand Coutumier, whereas the Transaction Coutumier you're more inferring, albeit with pretty high certainty, you're inferring the existence of a link. Normand, not Ormond, but anyway. This is essentially what ensured that Normandy remained a separate legal jurisdiction within France. Because there are two things that essentially, for our story, needed not to happen. One of them was that Jersey needed not to be absorbed. Jersey and Guernsey needed not to be absorbed into England. And the other is that Normandy needed not to be absorbed into the general run of France, because the first one would actually just end Guernsey as a separate jurisdiction. The second one would have inevitably thrown up barriers and made it more difficult, less easy, the flow of law, certainly anciently. Now, Chateau Normand has actually been used as a source of law. So Vaudin and Hamon. There are certain cases, and both islands have these cases, which are almost like universal examples. If you want to give an example of a commentator or a document being cited, Vaudin and Hamon is like your guess, because pretty much everything was at some stage cited in Vaudin and Hamon. Snell and Beadle is its Jersey equivalent. So then, in terms of the development of Norman law, they had this thing called styles of procedure. Again, building on the Grand Coutumier. The gloss, which is a very important document in its time. It was the main sort of like textbook or sort of attempt to interpret the Grand Coutumier before Terrier. I mean, certainly I don't know, does Le Marchand refer to the gloss at all?
Not as I recall, no. He refers to Terrier, refers to the gloss.
Yeah. I think that perhaps shows the extent to which the approbation did, to some extent, if not, didn't close off looking to more ancient Norman law, but certainly it placed it at a greater distance, because in Jersey they very much, certainly after the 17th century, they very much referred to these earlier documents, the gloss, and they criticised writers for not knowing anything, certain French writers of not knowing anything about the gloss. Whereas if Le Marchand, writing around the same time, wasn't doing it, it's because the approbation had put it at a greater distance. So 16th century commentators, so this is still before the Costume Réformé, and we're now dealing with people who are beginning to come into real importance. Rouillet, cited in Vaudin and Hamon, his text of the Grand Coutumier was the one that was used in the Channel Islands for centuries. It was used by the Royal Commissioners in 1848. And finally, Terrien. Now, Terrien has a nice, massive length of citations. That won't be all the citations by a long way. It contrasts greatly with the citations in for the others, much more lengthy, because he is of foundational importance in Guernsey law. Rouet, less general details, can just skip that. Now, Terrien, you don't need to know the name of the work Terrien wrote, no more than wrote his commentaries or something like that. That would show a good amount of knowledge. You don't need to know or memorise the entirety of the long title. He died in the 1570s and was published posthumously. Now, the interesting date in this is that date, which is 1654, which is interesting because it's after the Coutume Réformée in France, therefore after the royal redaction. So it shows that he remained important in Normandy after the Coutume Réformée. That's not surprising because the Coutume Réformée largely drew from his work, but it showed that having a redaction doesn't draw a line under pre-existing commentary. And when you think about sort of English law, it's no different to when you have like a statute like the Sale of Goods Act, which attempts to codify existing law. You still refer back to pre-existing cases. In fact, it's very often in any area where there is statutory reform that the previous cases don't lose all their relevance to understanding what is going on, and so it is here. And here we have the leading expert on the subject saying his contribution was the selection and arrangement of the primary material, because often the most important thing in law is the clear communication of ideas. If you can't find things, it's very, very hard to do anything with it. Now, the whole reason is around this time that the Henry III of France, or rather his officials, because I don't believe Henry III would ever have got exercised by issues such as administration, ordered that Normandy should get a code. It had previously been ordered by the French kings in about 1454 that every customary area should have a code, and Normandy had just ignored it. And what the King of France said, or rather his officials, was that their law was split amongst too many documents, obscure, hard to find, often anachronistic, so it needed a redaction. And Terrien's work, which was just been published, essentially became the foundation for that particular work. Now, what do you say about Terrien? What else can be said about Terrien in terms of commentary and comments? Now, this is the Royal Commission of 1848. These are the Royal Commissions sent by the British government to inquire into the Channel Islands on criminal law, as I said before. The reason why they were sent, can anyone think of why Britain might send Royal Commissioners to Jersey and Guernsey to inquire into their criminal law? And the reason why I asked that question is not entirely appropriate here, but it's an idea of me, which I think is useful to get into to understand, is that historically Britain has most commonly got involved in the governance of Jersey and Guernsey when the islands have been a nuisance, when people from Jersey and Guernsey have so fallen out amongst themselves that they start basically running off to Teacher to try and settle the squabble. And in the actually we'll come to it in the Approbation, actually arises from essentially that dynamic. And in the 1840s, it was actually entirely Jersey's fault. Jersey was squabbling amongst itself with, on constitutional reform and on being liberal or conservative. And the result was that commissioners were sent from London to inquire into what was going on. And they particularly comment when it comes to 1848 and Guernsey, that as far as they can tell, everyone seems to be perfectly happy and living amongst themselves and not causing anybody any harm, which is probably why you actually don't end up with a Royal Commission into your civil law, which means that the slightly often better report into the state of and the nature of customary law and its sources actually comes from Jersey. There's no Guernsey equivalent, simply because you weren't causing any trouble amongst yourselves to bring about such a thing. But this is essentially comments which were made by Ontario, and the same comments were made in the 1847 report in Jersey, which was that they found Terrian to be rather indigestible, a very poor as a source of law. Now, the thing was that they entirely misunderstood what Terrian is trying to do, which is that Terrian is trying to write a commentary on customary law, trying to make comments on the ancient coutume, how it's being applied. He cannot possibly just wish away ambiguities and difficulties within Norman customary law. They criticise the Terrian for including material which doesn't seem to be part of Norman law, but that's just when they bring in Roman law or edicts from the French king. But these are things which customary law drew in. So he's writing about customary law and the law of Normandy as it actually applied, not as it theoretically should have applied in the rather purist sense that the commissioners of the 1840s had, which is that it had to be a development from what was existed hundreds and hundreds of years ago and nothing else. And of course this means that when we get to it, when the Approbation adopts Terrian, it is adopting something which doesn't necessarily purport to set out clear rules in itself, because it can't. It can discuss, it can say what's the better one, and sometimes there will be clear rules. But the unsatisfactory state of customary law, which led to the French kings ordering the coutume réformée to be done, and done now, after 120 years of ignoring the instruction, was the state of the customary law that Terrian was writing about, and he couldn't wish that away. Is that fair to say? For the benefit of the camera, Gordon.
I have another.
But you get to the 1861 Royal Commission to Jersey, and this is a good contrast, and it's worth keeping this, not just ignoring it because it's a Jersey source. This would have been a Guernsey source as well if you'd been causing trouble enough to make it worthwhile the British government to spend the money to send the same people around Guernsey. But you weren't. And what they said was, actually, this is the spot-on real point for customary law, which is whatever might seem the limitations from an outsider, he was being used. It was the custom of Jersey to use this source. And as I said, he had a conspicuous place in Jersey. This was despite there being no approbation, despite there being no official approval of Terrian. So the fact that somebody has a conspicuous place in the usage of the lawyers in the 19th century, that demonstrated their role in customary law. Is not necessary to decide whether or not that was theoretically correct, or whether it was theoretically correct for that process to have started. It is, as the phrase goes, it is what it is. That is custom, when something is just because it is. And as Gordon was saying before, talking about the procedure of the Royal Court, the fact that the procedure is being used is self-validating as the custom of the court and as the rules of the court. And if the court was to raise itself up and issue a declaration that a particular way it's gone about things actually has turned out badly and it's going to do something else, then that would become the new starting point on which new custom would develop. So Terrian in the courts. Now, one of the things that you have to do in Jersey, and one of the things which we'll have to address, particularly when we get to the revision, is do you need to memorise the key parts of these quotes? Do you need to know greater authority and ascribe it to Valden and Hammond, and high authority and ascribe it to Bowden and Richardson? Because essentially that's one of the things you do in Jersey. But the point of these quotes is actually these are all Privy Council cases which stress the importance of Terrian in customary law. And Valdenhammond is, of course, a Sark case. I think the others might possibly all be Jersey cases.
I think so, yes.
But essentially, the Privy Council is saying this generally about customary law, and of course, why are they saying it? Why are they saying it? And the answer is because local lawyers have pitched up in London before the Privy Council, and that's what they have been saying, and that's what they have been demonstrating with the material they put before the court. Because a court, as we said earlier, is often only as good as the submissions and the evidence and the sources of law to put before it. And those that are put before the Privy Council historically have led to this position. And it would be quite impossible for anyone to seriously, from either island, pitch up and say that Terrian has any other sort of place, assuming, of course, that he's relevant to the particular area of law. So, the abrogation des lois. Now that's what Norman customary law is, and now we have to, which ultimately you have to do first, and now we're doing how it gets firmly admitted into Guernsey law in 1583. The background to this was, as I said, Guernsey making a nuisance of itself, a dispute within Guernsey as to how justice is being administered. Now, when you think about Guernsey customary law, ye olde days, it would be very easy, if you were the judges of law, to simply make it up as you go along. Because you have this ancient document from the 13th century, which doesn't actually have much substantive law. You then will have sporadic documents from Normandy, which will have arrived at various points in time, hopefully, which you might use, but they're not really addressing you. And then you've got certain local customs that may have survived, arisen. So what the law is often could be very unclear, and a feeling arose amongst many that the bailiff and jurats were essentially applying their own sense of what was right, what was wrong, and of course doubtless, as was the habit of the time, what was in their interest. So they wanted things sorted out. They wanted essentially the proper customary law to be applied. So naturally, the Privy Council said, so what is this law? And after various attempts and false starts, the Guernsey sends what is now known as the approbation, which is a very, very short document going through Terrian and saying, this bit applies, that bit doesn't apply. So, for example, on Terrian page 17, it says, our custom accords with this first chapter. Just nice, simple, that. So, nothing more than that. And that's not a very useful statement if what you're actually dealing with is a chapter which is going to be quite discursive in many places. When you think about what were perceived as the inadequacies of Terrian in providing clear rules, as viewed by the 1848 Royal Commissioners to Guernsey, here you have people saying, our law, look at that chapter. Or maybe with greater notes on on some of the other chapters, but still fundamentally tying it to the works of Terrian. Now, what unfortunately happened was that this particular work was probably never meant to be anything other than to try and inform the Privy Council in a rough and ready fashion, and does rather suggest it's a bit like a student who hasn't given enough time to finish their essay and sends in a draft instead. But instead the Privy Council says, stamp, order in council. This is your laws. So that's legislation, and primary legislation. Something wholly inadequate for the job. Meanwhile, as we've seen in France, in Normandy, they're doing the job properly. And from a historical perspective, it's quite confusing as to how it could have been allowed to have essentially had a half-baked redaction of Norman customary law sealed just before a proper systematic redaction of actual Norman customary law was taking place in Normandy. But that is what happened. It says, the Commission's commentary on Terrien's commentaires was approved by the Privy Council. A versus R. Nice, clear, simple statement. And because it's an order in council, it does sit to some extent like a cartoon, like a redaction, albeit that it actually fails to really do that job due to its lack of clarity. And also because it actually failed to note down really what was people's sense of what the customary law was. So you only have to fast forward to about 1605, as mentioned by the 1848 commissioners. You only have to fast forward that time, and people are already complaining that the approbation, far from codifying customary law, actually was contrary to customary law in many places. Now, whilst it would be useful to deal with much on purely in order when it comes to local commentators, it's important to mention him here, because Le Marchant, which is this chap, wrote a 17th century commentary on l'approbation, arguing it misstated Guernsey's customary law. Now, Le Marchant, and I think a wrong comment did get through in the study guide where he's referred to as a lawyer, which is my fault.
He was a cleric.
He was a reverend. So he actually wasn't a lawyer at all. He was a vicar. And he took his time in producing this work because the whole issue exercised him a lot. So I don't know whether he was just being a barrack room lawyer or a concerned citizen, but when you think of that, vicars and reverends were amongst the most educated people of society in that day, he would have been almost as well qualified as anybody to write these to write a commentary. As I note here, he's particularly exercised about the approval of the use of torture in Guernsey as part of Guernsey customary law, as it never had been anything to do, at least not those particular tortures. So here we go, we have the complaints, so in 1605. But the problem, of course, is that it's an order in council. It is legislation. So you can't just set aside a law because the law's wrong, because the law's stupid, because the law's a mistake. If you remember, those of you who've done sort of English constitutional law, you might remember Pickin and the British Railways Board. You know, just because a private act of parliament was obtained by fraud doesn't make it any less of an act of parliament. And just because this was derived from a piece of hashed homework and a rush of blood to the head by the Privy Council doesn't make it any less an order in council. Which is why it's recorded in the evidence before the 1848 commissioners that even when the Marchant disagreed with it, you couldn't just abrogate l'approbation. You couldn't, although it should be added that there were various chapters on criminal punishment that effectively had been abrogated by non-usage. So, and for this I am particularly indebted to Gordon for because how these things are used in practice often doesn't necessarily come out from examining the documents, because conducting sort of the research to write the study guide, you're immediately struck by if you put l'approbation or approbation or any form of it into the search engine for the Guernsey legal resources, you pretty much draw a blank. So you start thinking, well, is it relevant? Is it relevant at all? And of course, the answer is it has to be. And the method for Guernsey legal reasoning is you start with Terrien, find out if it's approved by l'approbation, because obviously if it's disapproved expressly, then it's gone. And then you consider Thomas le Marchant, you consider him because he's the lens through which the approbation is viewed. So le Marchant would say that if the approbation actually creates a rule, then it's going to have to be followed as a general principle. Obviously you can say otherwise about the torture and the criminal law, but that's if it creates a rule, then it has to be followed. But often it doesn't actually create a rule. It's too vague. Terrien might be too vague. You then move, after you consider le Marchant, and get to the state of affairs for the approbation, and whether it's relevant, irrelevant, partly relevant, in theory relevant, but in actual fact can't be understood. You then move on to how customary law has developed in Guernsey and how it's admitted broader sources. But it is very rarely cited in practice in judgments, but key to the process of Guernsey customary law reasoning. Because in the end, if you were to be constructing an argument based on customary law, and it could be all very, very, very clever, but if your opponent could suddenly pop up with the approbation and say, but this is actually contrary to the approbation, clearly, you're pretty much dead in the water. But